Welcome guys. This is going to be part 2 of the civil liability series. So in this particular video here, we are going to be deep diving into negligence in a little bit of detail. So what's really important to know about negligence is that you can be asked a question about any of these 6 areas about negligence. So it's really important you know things like the elements of negligence, what are some of the impacts of negligence, etc. But what's unique about this particular key knowledge area here is you can be asked to apply certain concepts of this dot point to, say, for example, the key concepts dot point. So you might be given a case study about negligence in a SAC, and it might ask you about the limitations of actions and how it's relevant, and what causation is and how it's relevant to negligence, for example. So just remember, there's a lot of overlap between these key knowledge areas here. So as a reminder, be really familiar with the definitions of these ones here and how to apply it to these particular concepts specifically. All right, just a quick recap about what civil law is and what its aim is. Really want to make sure that as we're going through the slides for negligence, you're keeping in mind that the main aim of negligence and civil law in general is we're trying to get a person back to their original position before the wrong occurred. So just remember, if there's like a workplace injury as a result of failed duty of care, we're trying to get a person to the exact same position or as best possible position before they were wronged. And remember, it's done through things like remedies. So in negligence, it's very common for someone to be handed down damages or compensation as a result, because they'll suffer a variety of different losses. All right. Moving on, really important that we have a clear definition of negligence. So I guess what I would remember is that negligence is all about people failing their duty of care. And when people do fail their duty of care, what tends to happen is that a person gets some sort of loss occurred because of that failure. So it's really important to understand that generally, most of these negligence cases are avoidable. It's because someone has failed to do or not do something, and you know that lack of care has resulted in someone getting seriously injured, or sometimes even results in death. So when we look at the elements of negligence, it's really important that you do know all 4 of the elements, because you can get asked questions about whether people are liable or not in a case study, and it's important you know each of the 4 elements and whether or not they're relevant or not relevant to a particular case study that you might be given. So first element of negligence is that a duty of care was owed to the person injured. So for example, duty of care can be held by people like teachers, parents, lifeguards, business owners. A lot of people owe a duty of care to others to make sure we keep them safe from harm. Secondly, we need to prove that the duty of care was breached. So we need to prove that that particular teacher or that particular business failed to do something, and then they've actually breached a particular area. Thirdly, like we kind of talked about in the first video, we also need to prove what's known as causation. And just remember that we want to remember causation as that chain or that connection. And we need to, as a plaintiff, prove that the harm was caused by the breach. So we need to prove that there was a direct link between the defendant's actions and the plaintiff suffering some kind of harm, or being responsible for negligence. And lastly is that we obviously want to make sure that someone who is suing for negligence can prove that they have suffered some sort of injury, such as a broken physical injury, for example, or they've suffered loss. And remember, there's lots of different types of loss we need to be aware of, like your financial loss, emotional, mental loss, that sort of thing. Various different types of loss that lawyers will often put forward in court to try and seek compensation. All right, moving on. Our rights are really heavily protected in terms of civil law, like we kind of talked about in the last video. And how our rights are protected and continue to be so protected is through common law, which is known as court-made law. So judges can make decisions that help strengthen our laws or help strengthen our rights. And we also have statute law. So as things change in our society, Parliament or the people that are elected to represent us are going to make laws that help keep us as safe and as best free from harm as possible. So in terms of when we're looking at negligence, our rights are primarily protected through what's known as the Wrongs Act 19 58. So this is a piece of legislation made by the Victorian Parliament, which outlines various things to do with negligence, and it outlines significantly how our rights are, I guess, protected. So what we want to make sure that we're understanding about this particular slide is that the main purpose of laws and having negligence laws in place is we want to protect an individual's right to be safe from harm. So we want to live in a society that's peaceful, where people aren't causing harm intentionally, and we want to make sure that people's person and their property are kept safe from harm. So that's why it's really important that we have laws embedded to make sure that people are aware that if they do breach those laws or they do break these laws, such as in the Wrongs Act, they're going to face some kind of consequence. All right, moving on to limitations of actions. Just remember, limitations of actions are really important because it sets a time limit about how long you have to sue someone. So in negligence, I'm not going to read them all out, but as you can see here, we have these time periods in place. This is how long you have, for example, say negligence claims involving disease and disorder. You have only 3 years to sue someone. And I guess the reason we do have that in place is just to make sure that, defendant can get closure, cases are resolved really efficiently and in a timely manner. And lastly, we want to make sure that the quality of evidence doesn't deteriorate over time. So that's why we don't let, for example, the second one, we don't let someone sue someone 20 years after this particular event has happened, because the quality of evidence is going to be significantly reduced over time. So we want to make sure we have these limitations in place. All right, moving on to the defenses. I know the textbook outlines a lot more than 2 defenses, but for the sake of keeping this video nice and short and sharp, I'm only going to be talking about 2 of the defenses, but just make sure you're aware of defenses that you have covered in class, because you may be asked about some other ones as well, but there are more than 2 beyond this video. So I'll just pick ones that I feel like are quite common. So first one, contributory negligence. It kind of says it in the name. It's sort of where you contribute to your own harm that has been suffered. So a really good way I like to think about this is if there is a wet floor sign and you see the wet floor sign and you go and start running as quickly as you can past the wet floor and you go and hurt yourself, you've sort of contributed to your own negligence, so you wouldn't really have many grounds to sue. So it's really important that they are really clear about what your rights are, and sometimes you can actually cause your own harm and you can be held responsible for it, not the business. And like it says here, the plaintiff contributed to the harm caused by the defendant. So it might mean that the business is still slightly responsible there, but as a result, when you're suing them, you're likely to receive significantly less compensation. In the example of the wet floor, if you really voluntarily did all that action yourself, you probably won't get any compensation at all. But something like this defense here kind of reduces the liability or reduces the compensation that is given to the plaintiff as a result of the case. The second defense I'm going to look at here is what's known as assumption of risk. It is basically like you imagine yourself going to go skydiving, or you imagine yourself signing up for a gym. You'll generally sign a waiver of liability. And what a waiver is, it's you're accepting responsibility, that this is a high risk environment. It's like a high injury environment. So skydiving, there's obvious risks when you jump out of a plane. Even though you have 2 parachutes, there's significant amounts of risk. And that, why we have this assumption of risk is that you've accepted it, and hopefully it takes that liability off the defendant, so that if something wrong does happen, they can say that you voluntarily accepted that risk and therefore we are not liable. But there can be instances that goes beyond the waiver and still can hold a business responsible. So it kind of depends on a case-by-case basis. All right. Lastly, when we look at the possible remedies, the most common type of remedy in a negligence case is generally money, but a good way to think of it with the legal term is compensatory damages. And there's 3 different types I'm going to mention here. Specific damages, so these are really easy because you can calculate them to the dollar. This particular person had a $43 x-ray, a $180 specialist appointment. We can give them that exact amount of money in terms of compensation. So it's really easy to calculate that loss. The second one, general damages. This is basically where you cannot calculate the damage exactly. So someone suffered long-term depression, they own a business, for example, and they've lost 2 months of business earnings. You can't put an exact dollar figure on how much a business has lost, so they kind of have to estimate or give a general amount of damages. And lastly, we've got aggravated damages is awarded for insult to humiliation of the plaintiff due to nasty or offensive behavior. So as you can see here is that if someone is found liable of negligence, like a business, for example, the court could impose any one of these 3 types of compensatory damages. And often what you might see is there might be a blend of all 3 or a blend of these 2, for example, to help get that person back to where they were before that loss occurred. So if someone has suffered a workplace injury because the business failed their duty of care, chances are they're going to have specific costs like ambulance and medical expenses. But if they have long-term loss of happiness, depression as a result of that particular thing that's happened to them, then obviously we need to implement general damages as well. The last little bit of this video is that we have the impacts of negligence on the plaintiff and the defendant. I'm not going to read them all out for you, but here's an idea about some of the things that can happen as a result of negligence. Some really unfortunate ones is someone has a permanent physical incapacity, such as they suffer a spinal cord injury. No amount of money is unfortunately going to get them back to where they are. Another really common one is that when negligence happens to another person, there's a lot of emotional impact of the breach. So, they might be scared about interacting with the public again. They might be scared about interacting with machinery again if that's a result of their loss. So it can cause long-term and short-term consequences or impacts. And lucky last, impact on the defendant. So if you imagine that if you're a business and you get found liable of negligence, it could have a massive hit on your public perception. Your reputation can go significantly downhill. And like I've kind of got in the last 2 dot points there, civil action can cost a lot of money. If it is a big, high-profile negligent case, it could cost the company millions of dollars, which could force them into bankruptcy, and especially if they have to sell their assets to kind of pay back to the plaintiff as a result of that loss suffered. All right, lucky last, a couple concluding points is that it's really important that those key concepts we looked at in the first video, you know how to apply them to negligence. So for example, that standard of proof is about the level of evidence required. If you were given a case about negligence, you could tell me that the standard of proof is, on the balance of probabilities, and be able to explain that. Really important that you know those 4 elements of negligence and once again, how to apply them to a case. A very likely scenario is that you get given a case study involving negligence and you have to mention how the elements are either present or not present in a case. Thirdly, be aware that for the defenses to negligence, like I said, I've only mentioned 2 in that video. I'd suggest studying the ones that you have learnt in class because there are significantly more than 2. And lastly, with the impact of negligence, just remember you need to know the impact on both the plaintiff and the defendant. Some people get confused and just talk about just the plaintiff, but just remember, have to be able to talk about both. See you guys in the next video for defamation.